So our question today for Frequently Asked Questions Friday is, what should I do with my estate planning documents after I've signed them? This is a question that we get frequently after people have signed their documents at our signing meeting. And the truth of the matter is it's personal preference what you choose to do with them. But there are some guidelines that I can share here that I think are somewhat best practices. So the first thing is that you need to put them in a safe place. So our policy here at Cardinal Estate Planning is that we give all of the originals back to the client. Not every law firm has this policy. A lot of law firms keep original wills here in Pennsylvania, but we've just chosen that that's not what we're going to do here. So we give you all of the originals back. You then need to put them in a safe place so that they won't get lost. And also, if you can, try to avoid putting them in a place where they might get wet. So fire protection is important, water protection is important. What I don't recommend is taking them and putting them in your safe deposit box. The reason that I don't recommend this is it may be challenging for someone to get a hold of them in an emergency when they need them, if that was the choice that you made. So I prefer that clients would keep them somewhere at their house. Maybe they keep them in a fireproof safe, and hopefully also have water protection. So if you go on Amazon, you can actually find fire and waterproof bags. So even if you don't have a fireproof safe, that might be a good idea. Some other attorneys I've spoken with in the past recommend that their clients put their estate planning binder into a waterproof bag, just to make sure that even if you do have a fire and say you put it into a fireproof safe, that the documents are safe from the water damage that may occur due to that event occurring. In terms of who to give the documents to, I recommend that you share with who you feel comfortable. So many times my clients are naming their children as agents, and they ask me, should I give a copy to my son or daughter? And I say, it's really up to you if you want to do that. If you feel like that's something that would be helpful at this point in time, that's good. But the bare minimum and the best practice by far is to at least make sure that they know where to locate the documents and access them in the event that something happens and they need to. So whether they actually have a copy in their own personal possession or not, that's a matter of personal preference. The other thing that comes up pretty frequently is the healthcare power of attorney, or healthcare directives. So clients often ask me, should I give this to my doctor? And my answer to that is, again, it's really personal preference whether you want to do that. I do know from my own experience, every time I go to the hospital, even just for blood work, they ask me if I have a living will. And so, the idea is that they collect these, and then in an emergency, someone won't have to produce it. It'll already sort of be a part of your file. And so my recommendation is that if you feel comfortable, you go ahead and share that with your doctor or other medical providers. I've chosen to do that with my own documents, and I think that's a fine practice. This is also a good reason why financial and healthcare powers of attorney are often separate documents, because you may want some people to have the financial document, but not the healthcare document. So I hope that answers the question of what you should do with your documents after you've completed your signing. We would love to hear any questions that you have. I would really like to answer them for you. So go ahead and submit them in the comments on Facebook, or otherwise just get in contact with us. And thanks for listening.